sometimes I've heard people ask me, hey, this technology is moving so fast. I want to skip the search and just file it right away. Does that ever make sense? Or are they taking too big of a risk?
So I grew up in Illinois, also went to University of Illinois for education, got my electrical engineering degree and my law degree there. After law school, I lived in Chicago for about 8 years. I practiced at a little patent boutique in Chicago that's no longer around. And then I headed west. I made a pit stop in Phoenix, worked with the firm called Snell and Wilmer there for a couple of years. And then I completed the trip west and went to California. And in California, I worked with several pretty big law firms. Worked for a while with Hogan Lovells, DLA Piper, Norton Rose Fulbright.
Okay.
Yeah. All of the big firms, all the big IP firms.
Yeah. I was billing a lot of hours.
I bet. Yeah.
Yeah.
So Troy, so for those that aren't familiar with big law, maybe some non-lawyers out there, what kind of firms are these? Harken back. What type of clients might you have been helping and work you've been doing?
Yeah. So these are large global law firms, the big law firms that I worked at in California. Generally speaking, they're general practice firms. So they do all kinds of, not just patent law, trademark law, but all kinds of law. And I was always involved in patent prosecution for the most part. Got some trademark experience as well. I still do a little bit of trademark work to this day. Not nearly as much as Matt, I'm sure.
You do a lot more patents than I do.
But yeah, during my time at these firms, I was generally working for, really pretty much large corporate clients. Towards the end of my time at big firms, I was doing a lot of work for Japanese companies, actually. For about 10 years, I was in Japan for about a month a year. Worked for companies it was really cool. It was really cool. But I was doing work for companies like Kyocera, Seiko Epson.
Yeah.
Nice.
Yeah, big companies.
That's really cool. My trademark professor here in Minnesota was bilingual, spoke Japanese, American, but spoke Japanese, and just raved about Japan and their IP systems, and very cool.
Yeah, it was really enjoyable, great experience. But after working in big law firms for 15 to 20 years, decided to go out on my own and start my own practice, and that's what I've done. So continuing the same sort of work, but mainly for smaller companies and individuals even.
Yep.
And it's been really rewarding. It's great to work with solo inventors, small companies. Yeah, because there's actually a lot more teaching involved, and explaining the patent system and how things work. When you're working for a Kyocera or a Western Digital or a Seiko Epson, they know all of that. There's not so much teaching involved because they already know it. They have in-house IP departments. I mean, it's rewarding. You're working on some really great technology, but not so much the teaching element, that I'm now getting and I'm actually really enjoying. In a way, I kind of feel like I've come back to my roots as a patent attorney. I know it sounds strange to say, but it's true.
That's great. Yeah, I mean, given all that amazing background, which actually some of that I haven't heard yet. It's awesome, and we get you here, but we're fortunate to get your time to share with our clients at the initial consultation, which is the very first legal meeting that they have and the first interaction. I'd like to talk about that, and what it's like for a client. Maybe you can picture one and kind of describe that meeting. What do you try to cover? What don't you cover? What's involved in that meeting, and so maybe answer some of that nervousness that maybe some inventors that might be listening are facing now.
Yeah. So, well, the first thing to say is, we do we do video conferences. We use Google Meet, and that's very helpful because, a lot of inventors, they like to see who their attorney is. And another great thing about Google Meet is, it enables document sharing, screen sharing. We can go over documents together. So it's been really helpful to do things by video. Especially when you're talking about something complex, it's great to be able to throw up a diagram and talk about it together, with the inventor.
Absolutely. Yeah, and I think that's a big point. I mean, I think you mentioned it even today before our show. It kind of was the impetus of getting you to come on. By the way, thank you for coming last minute. Is that
Sure.
you get often feedback from people saying, you know what, this isn't common, even though we're in 2024. It's not common yet that law firms are willing to meet virtually and we're offering video. They expect you to come in or expect you to just handle it on the phone, and we're taking it to the next level here at Bolt.
Yeah, and I've gotten some really good feedback from inventors that they really enjoy meeting in that kind of scenario. Yeah, so in one of these, we call them consultations, initial consultations. Typically the first thing that we will do is, we'll have some introductions, but then I'll ask the inventor to tell me about their invention. And usually they've sent some information about their invention beforehand. So I usually know something about it, but we'll talk about it together. I'll try to get out of them, what are the real key features of the invention here? What problem are you solving? How were things done before? Try to draw out the real key features of the invention from them. That's usually the first thing that we talk about. Next, usually I'm talking to an individual solo inventor most of the time, sometimes small companies. I try to gauge their experience level with the patent system. Have you ever seen a patent? Do you know anything about the patent system? So I'll start in by explaining, just a brief introduction to patents, starting with, hey, what's the difference between a utility patent and a design patent? And then based on what they've told me about their invention, I'll try to guide them down one of those paths. Sometimes it'll turn out, a lot of inventor, they're just not familiar with intellectual property. Sometimes it happens that what they're really looking for is a trademark. And, in that case, I'll guide them towards MAT. So we get into the patent system a little bit, types of patents, utility, design. And then one thing we do, one of the first things we want to do is make sure that their invention is something that's eligible for a patent. And so we will go over that, the different types of eligibility, and give them an indication, is this something that's patent eligible or not? And most things are, but there are a few things out there that aren't patent eligible. So we'll get over that initial hurdle, and then after that, and once we've gone over the patent system a little bit, what we like to do is put up a timeline of the whole patent process to show the inventor what's going to be involved in the process, starting from this phone call, this video meeting, and going all the way through to patent issuance. So we talk about that. Inventors are often surprised that, it is a little bit of a lengthy process between patent searching, patent drafting, and then you get into the patent office part of the process. And, that whole process can take several years sometimes. So that's often a little bit of a surprise, but it's
Right.
something that inventors about.
Yeah. Let's talk about some of the snags that you might have. Do you ever have clients that are really hesitant to divulge their invention? Are they worried about talking with you, even though you're an attorney? How do you overcome that?
Yeah, that happens quite often, actually. Yeah, naturally, often, an inventor, they've been thinking about this idea for a very long time, and rightfully, they've been keeping it to themselves, which is something that we always advise an inventor to do, is to keep it under wraps as much as possible until they've initiated the patent process. So yeah, they are reluctant to divulge, but everything an inventor talks to us about is protected by attorney-client privilege, and it's kept completely confidential. We do
I'm sure you
often have to get that.
You have to tell them, hey, even if you don't.
And even then, sometimes they're reluctant to divulge. But that is something to talk about the invention, we need to talk about the invention, right? Usually able to allay those concerns before we get into the discussion of, the invention.
And the outcome, of the console, let's say, and we're toward the end, what does the client get? What is the result of that meeting?
Yeah, so the result is, we're trying to provide some guidance. So usually we're going to, sometimes the invention may just not be at a stage, it may not be ready to even start a patenting process. And in that case, I'll say, look, you need to do a little more work and give them some guidance on, on, getting a proper disclosure together. And, on that point, any inventors listening, it is really important to, for good record keeping, to really write your ideas down, sketches, keep track of all of that information, because the more information you can give me, the better I'm going to be able to understand your invention, and the better guidance I'm going to be able to give you.
Right. Yes, I love that.
Yeah, that's very, very important. If I was to say, one thing to an inventor, it's write everything down, keep track of everything, get it out of your head and put it on paper.
We got one question coming here from William. He's got, let's see, do you have a recommended online resource for NDAs, non-disclosure agreements, when reaching out to have someone do the drawing for the patent? I have a ton of questions and don't want to derail the stream. William, don't worry. Feel free to derail, by the way. So Troy, I'll let you answer this one if you'd like.
NDAs are useful. One thing I tell people, when you get into the patent process, ultimately, hopefully you're going to get some patent protection at the end of the day. But in the meantime, you really don't have any protection until your patent issues. So an NDA, that gives you a layer of contractual protection on top of the patent protection. NDAs are, as being contracts, they are governed by state law. So, you want to find an NDA or a consultant attorney in your own state, where that NDA is going to be executed.
Well, I would say feel free to shoot me an email. I have a really robust network of business law firms and business attorneys. Like Troy was saying, we can make an introduction to you. I would not recommend grabbing an NDA online as published. If you want it to really be something you can use to rely on, to be enforceable in your jurisdiction, you want to spend that, a few hundred, maybe even $1,000 or so or more, getting that contract buttoned up.
Yeah, I like that, JD. I would also say too that, if you are reaching out to one of these legitimate patent drawing companies, we have one that we use at the firm pretty frequently, but if you're reaching out to them, they might have something in their terms of service that covers you. Also, they might have their own non-disclosure agreement that you can request them to sign or send to you to review, and that way you might save yourself a little bit of money. I would look at that too.
Perfect. Anything else you wanted to mention, maybe shed some light on what a legal consultation, that first meeting is like, what you'd like people to know about, anything?
Usually the outcome will be a recommendation. If an inventor comes in with an invention and a good disclosure, usually my recommendation is going to be to start with a patentability search and opinion. And what that is we go out and do a search of the prior art, issued patents, published patent applications, non-patent literature. And basically what we're looking for is, is this idea new? Is your idea new? Has it been done before? And we want to find that up front because, for one thing, if we do find that the idea is already out there, which, we hope it's not, but sometimes it is, you can save a lot of time and money by, if you're not going to get a patent, that patentability search and opinion is a very valuable investment because it prevents you from spending, continuing down the process when you're ultimately not going to get a positive result, most likely. That's not how we want the outcome to be, but sometimes it is. Now, if we do the patentability search and opinion and we don't find your idea, then the next step of the process would be a patent application. You have a choice. You can start with a provisional patent application. You can go with a non-provisional application. Oftentimes, inventors like to start with the provisional application because the requirements are a little less strict. They can generally be prepared faster and be filed faster, which is often very important for an inventor. They want to establish a filing date as early as possible. A filing date is presumptively your invention date. So once you get a filing date, you've kind of put your flag in the ground, and anyone that comes after you is trying to file a patent application on the same idea, you're going to have priority rights over them.
Sometimes I've heard people ask me, hey, this technology is moving so fast, I want to skip the search and just file it right away. Does that ever make sense, or are they taking too big of a risk?
In my former career, working for very large companies who have teams of engineers, they have a very good idea of what the prior art is. So maybe for a very large company with those kind of resources, it may make sense for them. For, you know, an individual inventor or a very small company who doesn't have those kind of resources, you know, it's very difficult to know what's out there in the prior art. So, you know, usually, in my opinion, it's the best move to have the patentability search done first. You know, not only for you to know what's out there, but it also allows us to write a better patent application for you. When we know what the prior art is, we know ultimately what we're going to have to distinguish over in order to get a patent allowed. And that helps us to write a better patent application when we already know what's out there that we're going to have to deal with when it gets into the patent office.